Welcome viewers. Today's lesson is about special courts and tribunals, their functioning, powers and jurisdiction. This lesson will look at the special courts and tribunals in terms of the need to set up such special courts and tribunals and the different forms of adjudication and dispute redressal which have been provided for by the law. Special courts have been formulated keeping in mind the need for speedier trial of certain offences, and various statutes have established special or designated courts to try cases under those acts. Tribunals, on the other hand, are very different from special courts. They are specialized courts and they only resemble a court and are not like courts entirely. Although tribunals also perform an adjudicatory role, the procedure followed and the powers that the tribunals have are distinct from those of courts. The need for tribunals and special courts is the need for having distinct forums to decide on disputes which an ordinary court may not have the time or the expertise to decide on. Tribunals are usually established to deal with one kind of disputes such as labor tribunals or tax tribunals, or recently the company law tribunals, where persons who are well versed in that particular area will adjudicate, while in special courts, although the court could only take up special cases, there is no requirement for special knowledge in that area. We will explore the different special courts and tribunals that have been established in India and their functioning. The objectives of this lesson are to understand the difference between a court, a special court and a tribunal, to learn about the difference in the functions of a court and a tribunal, to learn about the need for special courts and tribunals, and to understand the classification of courts and tribunals. The Constitution of India confers power on both the Union and the states to set up courts of their choice to deal with a variety of disputes under entry 11A of the concurrent list of the 7th schedule, which relates to administration of justice, constitution and organization of all courts except the Supreme Court and the High Court. Special courts and tribunals have existed for a long time in India. Industrial tribunals under the Industrial Disputes Act 1947 exercised jurisdiction over industrial disputes along with labor courts constituted under that act. Similarly, special courts were set up to try cases relating to the security of state since the colonial rule. Such courts were set up under the infamous Rowlatt Act 1919 and many others since then. In the state of West Bengal versus Anwar Ali Sarkar, a case decided in 1952, it was held by Justice Vivian Bose that the history of the special courts may also be considered while examining their constitutional validity. The need for specialized courts has been a long felt need for specialized justice as well as for alternative dispute redressal mechanisms to courts. The idea of Gram Nyayalayas or tax courts, educational tribunals have existed for a long time and are in the process of being implemented. The Law Commission of India, in its 124th report in 1988, discussed the vast jurisdiction that was being exercised by the High Court. It pointed out that the High Court has civil, criminal, ordinary, extraordinary, general and special jurisdiction that has been granted by the Constitution as well as several other statutes. The Representation of Peoples Act, for example, is one such legislation that confers the powers of an election court on the High Court. The court also has advisory jurisdiction as evidenced by the Companies Act. In light of these multifarious jurisdictions, the pendency of cases in the High Court is a major problem in the administration of justice. After listing the 14 kinds of matters that reach the High Court, the Law Commission suggested that specialist tribunals be established. Thus, the establishment of tribunals has been suggested as an important mechanism to deal with the need to create alternative forums for dispute redressal and the need for specialized justice. The Supreme Court in Re Special Courts Bill in 1978 held that the Parliament was competent to enact a legislation setting up special courts, and it was legitimate to confer on the Supreme Court an appellate power to hear appeals from such courts. It refuted the contention that only a special leave petition under Article 136 would lie from these courts. The Supreme Court also held that in the exercise of the power to constitute a new court, the Parliament may create a court that does not conform to the existing hierarchy of courts. In a study by the Vidhi Center for Legal Policy, it was found that while between 1950 to 1981, only 3 statutes provided for special courts, from 1982 onwards, 25 statutes set up special courts. Tribunals are not courts but are adjudicatory bodies, that is, bodies that decide disputes and are constituted by the state and vested with judicial functions. Such bodies are set up under specific statutes such as the Industrial Disputes Act, the Rent Control Act, the Income Tax Act, etc. These are established with a view to ensure speedier justice, as specialized tribunals which have the expertise to deal with these matters might resolve these disputes in a more efficient manner. The Administrative Reforms Commission, set up in 1967, recommended that these tribunals be set up in specific areas. The 42nd Constitutional Amendment introduced Article 323A and B to increase the number of areas where such tribunals could be set up, and also increase the position of the tribunals in the hierarchy between courts and tribunals. Article 323A and B introduced administrative tribunals by the 42nd Constitutional Amendment. Article 323A provides that Parliament may by law provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services or any post under the Government of India. Article 323B provides that the appropriate legislature, that is both centre and state, may provide for the adjudication by tribunals of any disputes, complaints or offences with respect to all or any of the matters specified in the article. A wide variety of matters have been specified in the subclauses of Article 323B. These include disputes relating to tax cases, foreign exchange matters, industrial and labour cases, ceiling on urban property, election to state legislature and parliament, essential goods and their distribution, and criminal offences. Article 136 of the Constitution of India provides for a special leave petition that may be filed before the Supreme Court from any judgment, decree, determination, sentence or order in any cause or matter past or made by any court or tribunal in the territory of India except orders passed by courts or tribunals constituted under the law relating to the armed forces. This special jurisdiction of the Supreme Court is different from the appeals made to the Supreme Court under its appellate jurisdiction, as well as the enforcement of fundamental rights under Article 32. The difference between courts and tribunals is that while courts and tribunals have always existed as different forums, the constitutional amendments made by Article 323 appeared to bypass the high courts, and this was challenged as being violative of the basic structure of the Constitution. Both Article 323A and B provided that a law by which these tribunals were to be set up could exclude the jurisdiction of all courts excepting the jurisdiction of the Supreme Court under Article 136. Thus, even the Supreme Court's jurisdiction was excluded in terms of all articles such as Article 32 except for Article 136. All the tribunals that were in existence until this constitutional amendment were within the jurisdiction of the high courts. The tribunals under Article 323 were suddenly elevated to the position of being on par with the high courts and thereby excluding the jurisdiction of the high courts. The questions before the court in Sampath Kumar versus Union of India as well as L. and Chandra Kumar versus Union of India were whether these tribunals could bypass the High Court in this manner and whether they could exercise the power of judicial review that is exercised by the Supreme Court and the High Court, such as the power to strike down a provision of a statute. The third question that was raised in L. Chandra Kumar was whether these tribunals, as they are functioning now, can be said to be effective substitutes for the High Court in discharging the power of judicial review. The Supreme Court in L. Chandra Kumar held that the clauses, to the extent that they excluded the jurisdiction of the High Court under Article 226, 227 and the Supreme Court under Article 32 were unconstitutional. One of the contentions before the court was that these tribunals were not functioning efficiently, and the Supreme Court held that if they were under the superintendence of the High Court, their position might actually be better. It was also believed that since the functioning of the tribunals left much to be desired and there was only a chance to file a special leave petition in the Supreme Court, the Supreme Court found that there were too many cases filed before it. There was also the aspect of cost of litigation and the location of parties. While those states which were closer to Delhi could easily access the jurisdiction of the Supreme Court, states situated much further away could not easily access the Supreme Court. The Supreme Court therefore believed that in the interest of justice, the High Court situated in each state should be able to exercise its jurisdiction to examine the decisions of the tribunals. It held that all decisions of tribunals, whether under Article 323 or otherwise, would be subject to the jurisdiction of the High Court. The need for special courts and tribunals. The tribunals were set up to ensure speedy justice, uniformity of approach, predictability of decisions, and to achieve the goals of specialist justice. The Supreme Court and various high courts, particularly the Andhra Pradesh High Court, discussed the need, role and scope of the powers of the administrative tribunals. The tribunals were established with the intention of setting up specialized bodies that are composed of members both from the administrative as well as the judicial side. The premise was that these specialized bodies would be better equipped to dispense speedy justice by a mix of administrative and judicial members. In terms of jurisdiction of these tribunals, the tribunals were created by statute, and the important question is whether they have the competence to question the legislature under which they are set up and to question whether the legislature is correct or not. The settled position is that tribunals, being creatures of the statute, cannot question the statute. They have the competence to examine disputes under the statute and to examine rules and subordinate legislation such as regulations that are made under the Act, but not the statute itself. Thus, the constitutionality of a statute cannot be raised before the tribunal. The courts have held that the tribunals are competent to hear matters where the wires of statutory provisions are questioned. However, in discharging this duty, they cannot act as substitutes for the high courts and the supreme courts, which have, under our constitutional setup, have been specifically entrusted with such an obligation. The tribunal's function in this matter is only supplementary, and all decisions of the tribunals will be subject to scrutiny by a division bench of the respective high courts. The tribunals will consequently also have the power to test the wires of subordinate legislations and rules. However, this power of the tribunals will be subject to one important exception, which is that they shall not entertain any question regarding the wires of their parent statute. Special courts have been set up under various statutes, such as the Special Court Trial of Offences Relating to Transactions in Securities Act 1992. Special courts may be set up by the statute, or existing courts may be designated as special courts. Setting up new courts would involve financial burden on the state, while designating a court only means adding additional responsibility to existing courts. In terms of the functioning of the special courts and tribunals, the Malimat Committee report, also known as the report of the Arrears Committee in 1989-90, held that several tribunals are functioning in our country. Not all of them, however, have inspired confidence in the public mind. The reasons are not far to seek. The foremost is the lack of competence, objectivity, and judicial approach. The next is their constitution, the power and method of appointment of personnel thereto, the inferior status and the casual method of working. The last is their actual composition. Men of caliber are not willing to be appointed as presiding officers in view of the uncertainty of tenure, unsatisfactory conditions of service, executive subordination in matters of administration, and political interference in judicial functioning. For these and other reasons, the quality of justice is stated to have suffered, and the cause of expedition is not found to have been served by the establishment of such tribunals. In his address at the celebrations of the Platinum Jubilee celebrations of the Income Tax Appellate Tribunal, which is also known as the ITAT, the Law Minister stated that the tribunals were brought in to replicate a system of administrative courts that were functioning in France, known as the droit administratif, which was a system that ran parallel to the civil courts. He stated that the intention behind this system was to ease the civil courts from administrative matters while laying separate standards for administrative disputes. The modern Indian Republic was born as a welfare state, and thus the burden of the government was to provide various welfare measures for the citizens, and this required statutes and forums for a quick settlement of disputes. The right to judicial review having been held to be a basic feature of the Indian Constitution, the right to appeal from any decision that adversely affects a party has become an indispensable need. Ordinary civil courts are not equipped to deal with such disputes and are burdened by procedure that is elaborate and judges who deal with a variety of matters. The expansion of laws, rules, regulations in the field of administrative law have led to the need for specialized judges, and the ordinary civil courts cannot perform these tasks. The recent decision of the Supreme Court in the Madras Bar Association versus Union of India 2015 also put its stamp of approval on the constitutional validity of tribunals, and in this case the tribunals established under the Company Law Act. The court, however, did have suggestions on the composition of the tribunal, the qualifications of the members appointed, on the term of the members, and measures to retain the independence and security of tenure of the members. In this case, a challenge was laid to the establishment of the National Company Law Tribunal as well as the National Company Law Appellate Tribunal on the ground that the Parliament had resorted to tribunalization by taking away the powers from the normal courts, which was essentially a judicial function, and this move of the legislature impinged upon the impartiality, fairness and reasonableness of the decision making, which was the hallmark of the judiciary and essentially a judicial function. Arguments went to the extent that it amounted to negating the rule of law and trampling the doctrine of separation of powers, which are basic features of the Constitution of India. The court, however, rejected these arguments and held that a legislature can enact a law transferring the jurisdiction exercised by courts in regard to any specified subject other than those which are vested in courts by express provisions of the Constitution to any tribunal. It also held that all courts are tribunals. Any tribunal to which any existing jurisdiction of courts is transferred should also be a judicial tribunal. This means that such tribunals should have as members persons of a rank, capacity and status as nearly as possible equal to the rank, status and capacity of members appointed to the court, which was till then dealing with such matters. And the members of the tribunal should have the independence and security of tenure associated with the judicial branch. The court also held that indiscriminate appointment of technical members in all tribunals will dilute and adversely affect the independence of the judiciary. The special courts established under different statutes exercise powers which are different from those exercised by the tribunals. To take an example, the special courts which are constituted under the SC/ST Prevention of Atrocities Act have the jurisdiction to try cases under this Act. However, in many cases, although special courts need to be set up, there is no difference between an existing court and a special court. This is what is understood as the designation of an ordinary court as a special court. Thus, the need for special courts and tribunals are two distinct needs. There is a need to set up more special courts and not merely designate existing courts as special courts. Similarly, although tribunals have been established under various statutes, the Supreme Court seems to be of the opinion that the tribunals must resemble the courts in as many matters as possible, such as the persons who are appointed to the tribunals, the security of tenure of the tribunal, and the members of the tribunal. Thus, the need for special courts and tribunals being very different, courts and tribunals ought not to be considered to be on par with each other, but must be understood as two distinct forums which have been constituted for two distinct purposes. In case of the tribunals, the need is to bring in specialized people, not necessarily judges, and for members of the administrative side to aid the judicial member in reaching a conclusion. On the other hand, the special courts are set up for speedier justice, to give justice in certain matters on a more priority basis, and in all other matters will function exactly like a court. The procedure that they follow, the punishments that they give are the same as those that an ordinary court will give. A tribunal, on the other hand, has very distinct procedure and has very different powers. In conclusion, we have examined that the special courts and tribunals can perform an important role in the adjudication of disputes in a faster, more informed manner as well as a specialized manner. The need for these courts is reflected both in terms of the pendency of matters before the traditional courts and the number of special courts and tribunals that have been set up post 1980. Although these may not immediately improve the situation of pendency of cases before the high courts and the supreme courts as well as the civil courts, they have now been accepted as an important tool in addressing the need for an improved judicial administration. I hope you have enjoyed this lesson. We will meet again for the next lesson.